That was clearly an argument from the county's perspective that ultimately at some point in the future they would have got around to providing these records. But the court's finding is they didn't, without the lawsuit being filed. They waited too long. They blew past their deadline. Cortland and Green both attempted to have communication with Lewis County. That didn't result in anything. There was a period of time they waited, and once they filed the lawsuit, then Lewis County, realizing, I would imagine, that they had failed in their duty to get these public records to the plaintiffs, then proceeded to try to accommodate those requests. To my mind, and I'm open to hear arguments at the penalty phase hearing, but to my mind, all of that goes towards what would be an appropriate penalty, which I'll determine after hearing both your arguments for this violation.
Do you wish there to be any further argument for the penalties hearing on the issue of whether Mr. Green and Mr. Cortland independently and separately should be receiving a remedy, or as opposed to a joint remedy?
Well, I'm certainly not going to tell Lewis County how to make their argument. I don't know ultimately whether it's a good use of the county's time to respond to that argument, because clearly there's a connection between plaintiffs. I think that's why the case was filed with the both of them together. So I guess what I would say is I'm open to both sides presenting whatever arguments they think the court should take into account. I'm proceeding with the thought process that this case, as pled, involved two individuals.
Thank you, sir.
You're welcome.
So Mr. Eisenberg starts out by talking about two requesters. That was my first issue as well. There's no mention of statutory analysis. There's no mention of the intent of the statute. There's no mention of RCW 42.56.550 section 4. That says any person. This court is bound by the plain language. Mr. Eisenberg comes up and argues, well, they didn't have notice that it was more than one person. The request was signed anonymous. Mr. Eisenberg doesn't try to construe anonymous as one person. He doesn't say how the request was signed could be construed as one person. I don't know how anonymous can be construed as anything. It's not known by definition. So I think this court is bound by the plain language of the statute, and that there should be two separate equal penalties in this case given for each man, because this is a remedial statute. Second of all, he talks about, Mr. Eisenberg talks about the amount of records. He talks about that Mr. Cortland was given notice that the amount of records, that there was a lot of records and it was affecting Lewis County's ability to produce documents. That was for another request. That actually isn't an issue in this lawsuit. If this court looks carefully at that argument and that declaration, it identifies a request not at issue in this lawsuit. And so I don't know how, when Lewis County argues that each request is factually based and we need to look at each request by request, why they're bringing in other requests in order to muddy the waters. We need to look at what Lewis County communicated to these men for these two requests in front of the court. And they don't address that. What they do is they try to say, well, in request number X, we did convey to you that there were a lot of requests, but you should have known that that communication applied to the production of all of your requests. As stated in declarations to this court, neither Mr. Cortland nor Mr. Green are mind readers. Lewis County did not diligently communicate Ms. Amron says that in her own declaration, and my clients cannot be held in order to know which request applied to which other request. That isn't communicated, and only the request in front of this court should be looked at. Lewis County also says that they wanted to work on these requests, and they say when talking about the explanation about information technology being shorthanded. But again, that's not really in the declarations, and even if that is somehow in their declarations, that's not in their argument today. Like I pointed out to this court originally, we didn't hide it in our brief. We went aggravating factor by aggravating factor, and we argued it in our brief. And Lewis County did not explain that at all. And that should be held against Lewis County because they just can't cherry pick arguments out of declarations and oral argument in front of this court. That's not fair to plaintiffs. They say that the improvements all started before the loss. They say the improvements on the production of documents to the Public Records Act, they hired new employees, etc. There's no proof of that in the record. There's no evidence of that in the record. In fact, they state that they believe that the public records officers started in August. These requests were made in May. How do we know that these improvements started before May when the requests were made? There's no evidence of that, Your Honor. They go on and they talk about that they talk about the public importance, and they say this is so far removed. Again, there's no evidence. There's no declarations. This is all speculation here. They didn't write a declaration from the Board of County Commissioners talking with their constituents and what their constituents were saying, and if their constituents were less concerned with Discover Lewis County over time, and it was only the newspaper who was writing about it. There's no evidence about whether there was less attention to this over time. The only evidence in front of this court is that there's continued newspaper coverage of Discover Lewis County over time. And that's the only evidence in front of this court, and that's the only thing the court should look at. And so when looking at this penalty overall, the first and second aggravating factors are admitted. The first aggravating factor, that there was a delayed response, is admitted on page 9 of Lewis County's response brief. The second aggravator is admitted that it did not strictly comply with PRA requirements. Mr. Cortland and Mr. Green also argue that this is a broad issue of public importance as demonstrated by the continued newspaper coverage. Mr. Cortland and Mr. Green also argue that there wasn't a reasonable explanation because Lewis County hasn't explained why information technology was shorthanded or how that implicated the slow production or the delayed response of their records, or why Lewis County couldn't have simply taken the extension. And there are several major Yusufian factors that are at play here with very strong implications, including deterrence. I don't know how many more times Lewis County needs to be brought in front of the Thurston County Court before they start strictly applying the Public Records Act, and that's what we're asking this court to help Lewis County do today. Thank you.
This, to the court's mind, is a penalty that is fair and appropriate. I'm adopting the other rationales that Lewis County put forth because I think they are fair and appropriate. And so again, for the reasons put forth by Lewis County, I believe it is correct that there's one per diem award, and that will be split between Mr. Cortland and Mr. Green. And I would sign an order consistent with those rulings.
Your Honor, can I clarify real quick? What is this court finding in regards to the issue of public importance?
Hold on 1 second.
I think it's important for appeal for this court to clearly delineate each Yusufian factor on the record.
Well, the court is not going to do that in that way.
The court has adopted the rationale of Lewis County regarding the Yusufian factors.